This is the current federal tax developments for the week of May the 26th, 2025. Current federal tax developments are brought to you by your state society of CPAs. This week, we're going to look at a few developments that took place here just before the Memorial Day weekend, beginning with a discussion of the fact the IRS has reduced the estate tax closing letter fee, a tax court case that defined the scope of review the court can enter into in passport cases, a court dealing with the marital deduction for bequests to trust, a case that looks at reasonable cause when you're giving advice or been given advice by a tax professional regarding late filing penalties, what works and what doesn't. We'll talk briefly about the No Tax on Tips Act and have a brief discussion about the bill in the House that cleared, the one big, beautiful bill that cleared, both of which have provisions that would eliminate taxation on tips. And we'll talk a little about that, as well as some of the other things coming up. We have a major league transfer pricing case involving Facebook and subsidiaries versus commissioner. That's not an area of my expertise, but it's an area that we'll at least discuss today and discuss some of the basics. And finally, we'll take a look at a case where Mr. Edward Zelinsky is going to go back to court against the state of New York regarding the convenience of the employer rule. We'll talk about why he feels that this time it may work, and also, what exactly was different this time, including some different law that he believes now, different case law that he believes now from the Supreme Court may help him, and an issue of the fact that one of the years involved was the COVID years where he was prohibited from going to the office in New York. So we'll talk a little bit about both of those. So with that, let's start out with the issue of the IRS reducing estate tax closing letter fees. This is a change that's implemented through an interim final rule, which I find an interesting terminology to be used here. Normally, Treasury is always referred to these when they impact taxes, income taxes, estate tax, etc., as temporary regulations, when they issue the rule. But in this case, it was called the term we see used in most other cases with Treasury rules, like the ones we see from FinCEN or the ones we saw from the SBA when we were looking at the PPP loans, the interim final rule, which basically is the same thing as temporary regulation. We also have a corresponding identical notice of proposed rulemaking, the proposed regs that are in this area. Now, this is the new fee we're going to be getting and some methodology behind it as to why we're getting a change now. Now, probably the big thing you're worried about is how much it's going to cost. And this new user fee has been reduced. Previously, the payment prior to May 20th was $67, but now the new fee is going to go down to $56. This will reduce it by $11. This reduction is due to a required biennial review. This review was conducted in 2023. It led to a new cost model, which determined a lower full cost for issuing the letters, which I think, most of us, if we have to get them, are going to consider that good news. Now, the effective date is for any basically fee request received by the IRS after May 2025, which was the date the interim final regulations were released and made effective. The Treasury and IRS found there was good cause to make the rule effective immediately without a prior notice or a prior public comment. Specifically, they felt that charging the higher fee during a comment period would be both unnecessary and contrary to the public interest. I doubt they're going to get a lot of arguments on that. Now, their authority to set fees goes back to the Independent Offices Appropriations Act of 1952, the IOAA, probably before many of us listening to this broadcast were born. Right? You got that in there. So, yeah, it goes back a ways. It was 8 years before I was born, so it's been around a while. Been around my entire life, I guess, presumably. Now, this act requires fees to align with policies set by the president, outlined in Office Management Budget Circular A25. The basic principle here is that services that confer special benefits to specific recipients should recover their full cost from those recipients. The IRS deems the estate tax closing letter a service that confers just such special benefits for which the cost should be recovered. Now, the agencies must review their user fees biennially, every 2 years, fancy term, based on cost changes, and the 2023 review prompted this update. Now, the methodology they follow SFFAS number 4, the Government Accounting Standard, for calculating full costs. So what's their cost calculation breakdown? Well, if you're watching the slides, there's going to be a lot of details on this. You really want to check it. They actually can walk you all the way through, and the write-up in the materials is also going to give you a lot of details about how to calculate this, or you can, just go read the regs. It'll have this in there. The full costs here include both direct and indirect costs. It includes personnel, overhead, and the like. They studied and came up with the direct, the request processing costs. This relate to staff time, reviewing the returns, and preparing the letters. This work is performed by workers who have GS5, GS8, and GS11 grades. And the average processing time for those workers is 0.65 staff hours per request. Now, this is based on the average of 8894 requests received in 2021 and 2022 each year. So average those 2 years. Total direct staff hours they computed for servicing those requests was 5,081 hours. And essentially, what they ended up determining, it included an indirect included 60% rate for campus employees, $92.50 annually. That was equivalent to 4.45 full-time equivalent employees, right? So full-time employees. The average salary and benefit cost per a full-time employee for processing roles, that totaled $67,355. So the total labor and benefits costs they computed for processing these sort of direct costs, were $299,730. They also had a few of these are pulled for quality assurance reviews every year. So this amount that were pulled, about 3% are reviewed, so 266 annually on average those 2 years. And each review takes about a half hour. That leaves the total direct quality assurance hours of 133. And those total quality assurance hours, including indirect, they charge 60% in for that, is 213 hours annually, which is equivalent to 1/10 of full-time equivalent, right? So the average salary and cost per full-time equivalent for QA employees is going to be effectively $95,460. So that means the total, I should say, should be in total, and then that reduced rate is $9,546. Is single one is that, so 1/10 is this. Now the total labor and benefits cost processing, therefore, is right under $310,000, $309,276. They have an overhead rate in fiscal year 2023 of 62.5%. So if you add that in, this gets us a total cost of $502,574. The cost per request, taking that $502,574 of annual cost divided by the 8894 average annual request, is approximately $56. So they updated their process now to go that route to reflect the new $56 fees for requests filed after May the 20th of 2025. The tax court this week took a look at how do they decide if there is a case challenging the IRS's certification of a significant tax debt to the State Department, which can cause you to lose your passport. When a taxpayer takes advantage of the review offered by going to the tax court of such a decision, what is the nature of the review the tax court can decide? Is it a from scratch review, or what's called de novo, or is it only a review of the administrative record? So this case is Alberto Garcia Jr. versus Commissioner, which is 164 TC number 8 that came out on May the 19th, 2025. This is an issue of first impression, which is normally going to have such things in a published tax court case, and it regards the scope of tax court review in cases challenging an IRS certification of a seriously delinquent tax debt under 7345A. That impacts the status of your passport, which is kind of helpful to have if you're going to leave the country. And more recently, it's become helpful if you don't have a real ID, let's say driver's license. That's one of the documents that counts. So you'd probably like to have that be valid. Now, the key holding of the court is that such reviews can be performed de novo by the court. It means the court starts with a blank slate, brand new record, developed by the court, and they are not limited to looking at the administrative record developed as the case moves through the IRS. So this significantly affects how these cases can be litigated and will be litigated. Now, in this case, the petitioner is Alberto Garcia Jr. And no question, he had a tax issue, right? He failed to pay federal tax liabilities more than $100,000 from 2007 to 2010. These were income taxes, employer taxes. The IRS pursued collections. They did liens, levy notices. But Mr. Garcia engaged in a limited collection due process. In a district court, the IRS sued in 2014 to reduce liabilities to judgment. Mr. Garcia did not appear. We'll get to kind of how that worked. And a default judgment was entered in August of 2014. In October of 2022, the commissioner certified Mr. Garcia had a seriously delinquent tax debt of $129,959.05 under 7345B. Therefore, the notice went to the State Department. Notice of certification, the CP 508C was sent. Bingo. You've been certified. Now, the taxpayer is allowed to challenge the certification as being erroneous in the tax court. This is under IRC 7345E1. Right? The primary contention of Mr. Garcia was that the default judgment received from the district court was void due to lack of service in the 2014 district court suit. His argument is if that judgment is void, the collection period was never extended. Normally, the IRS only has 10 years after date of assessment to collect tax. Now, they can go to court and get an then go to court and get a judgment, and that adds on to it. But he's saying if that judgment was not gotten, a valid judgment was not received in time, if that judgment's void and they can no longer get one now because they're past the statute, their liabilities would become unenforceable and the debt's not seriously delinquent because there is no debt. Now, the IRS said, oh, well and good, but the certification was proper. Now, the IRS position is the 2014, default judgment extended the collection period until at least 2034 under 6502A and IRC section, or 28 USC 3201C1, 28 United States Code. The commissioner presented a return of service claiming that Mr. Garcia was personally served with this information. Now, a legally enforceable debt is required for there to be a seriously delinquent debt. In essence, to be a seriously delinquent debt, it must be assessed, exceed a threshold, and more importantly, in this case now, be legally enforceable. Once the statute of limitation period has expired, or the IRS is allowed to expire under 6502, the debt's no longer legally enforceable. Ordinarily, the IRS has 10 years to collect after assessment, but if they obtain a judgment, the collection period is extended until the judgment itself becomes satisfied or becomes unenforceable, essentially buying them another 10-year statute, right, under the law. Now, the commissioner relied on the 2014 default judgment for this extension, claiming that as of today, essentially, or as of the time in question, or yeah, it really would be, I say, as of today, there's still a legally enforceable debt against Mr. Garcia. Therefore, State Department should be told you got to take this guy's passport. Now, the key issue, of course, is if a judgment's entered without personal jurisdiction due to a lack of effective service, if somebody sues you, never serves you to let you know the service took place, therefore, of course, you never knew to show up at the court, right? That would be a problem, right? Then the judgment would be thrown out. So Mr. Garcia's challenge to service directly impacts the judgment's validity, and thus that would impact at this point, under the facts we have, with no longer the IRS having a chance to go to court to get a revised judgment, there is no enforceable debt, never could be for this debt. Now, this was a matter of first impression, reported cases usually are. Now, under 7345E1, the court has the authority, and, quote, the word is to determine, keyword, whether the certification was erroneous. Now, the IRS, I should say the tax court, is going to decide what is the way the court should determine. whether a certification was erroneous. And so they looked at other language that covered other areas of jurisdiction to see what type of words had Congress used. In a deficiency case, the matter is considered a redetermination. And that has been ruled to be a brand new record gets started at the tax court level. Similarly, with historical innocent spouse cases, the court is asked to determine that they qualify for the status, and the court has said that is a new record. That is, in both cases, it is done de novo, right, starting from scratch. However, in the provisions of the whistleblower awards allowing you to go to the tax court, they only use the term appeal. And that has been ruled to be it's only reviewing the administrative records for an abuse of discretion. Similarly, collection due process cases, or I should say for abuse of discretion, again, only to the administrative record. We review the record as developed. We don't go develop a brand new one. They conclude that determine is key here. Determine in 7345E signifies review should be de novo from scratch. A brand new record should be made in the tax court. That means the court's not limited to the administrative record and consider evidence outside that record, like evidence regarding service in the district court suit, not merely the fact there was a judgment. You can look behind that information. Now, what are our applications, conclusions, and our implications for practitioners? The court found a genuine issue of material fact when they reviewed de novo regarding whether Ms. Garcia was served in the district court suit. His assertion of non-service despite the return of service is a factual dispute that the court cannot resolve at summary judgment. We'll see this again later in another case. Since this fact is material to the judgment's validity and thus the debt's legal enforceability, summary judgment was denied for both parties. This case will proceed to trial to resolve that factual dispute. The implications: the tax court review and passport cases can start from scratch de novo. It's not just the administrative record. Disputes about fact critical to certification, like the underlying judgment validity, may require a trial. That's pretty clear. And those attorneys who are in that area will need to be prepared to present evidence and develop a new record in court when challenging the factual basis of the certification, especially if it relies on external events or documents outside that administrative record. Marital deduction for a bequest to a trust. Interesting case today, an estate tax case. The case here is the estate of Martin Griffin versus Commissioner, Tax Court Memorandum Decision 2025-47. Decision was issued on May the 19th, 2024. The key issue is whether two monetary bequests from a decedent's revocable trust to the trustee of his surviving spouse's existing irrevocable trust qualified for the marital deduction under IRC 2056. This case required applying the terminal interest rule, the Q-tip exception, and considering state law, in this case Kentucky, on trust creation. How is it impacted? How does it work? And what exactly goes on in that area? Okay, let's talk about that. The decedent in this case was Martin Griffin. He died July 9, 2019. He was survived by his spouse, Maria Creel. Now, he had a revocable trust, Martin did, and he created the MCC, Maria Creel Irrevocable Trust, titled the MCC Irrevocable Trust 2018, or referred to just as the MCC Trust, based on the same day he amended his revocable trust. The revocable trust directed two bequests to the trustee of the MCC Trust for Ms. Creel's benefit. Right? There was a $2 million bequest, and per this, bequest said that it was to be held for her benefit with monthly distributions up to $9,000 adjusted based on the CPI. No specific direction for the remainder distribution upon her death was in the bequest itself. The $300,000 bequest was considered a living expense reserve to be distributed $5,000 per month for up to 60 months. Crucially, the bequest itself provided any undistributed amounts of this bequest upon Maria's death were to be paid to her estate. The trust terms, because remember, we're giving this to the trustee of that trust, term of the trust was irrevocable, explicitly stated in no event shall the beneficiary appoint to any part of the trust estate to the beneficiary's estate, the beneficiary's creditors, or the creditors of the beneficiary's estate. The default remainder distribution was to his descendants, not her estate. Now, the estate properly filed a Form 706 and claimed a $2.3 million marital deduction for these bequests, the $2 million and the $300,000. But they put it on the all other property schedule, non-Q-tip. They did not list any property on the Q-tip schedule. Okay, that's called a mistake, and Houston, we have a problem time. The IRS, noting this, issued a deficiency notice claiming the bequests were includable. The case is before the tax court on cross motions for partial summary judgment. Now, this is a de novo proceeding. We just went over what that means. That means the tax court review is based on the record before it, not the administrative record. And a couple of key Internal Revenue Code provisions. First, 2056A, the marital deduction, allows a deduction for property passing to the surviving spouse. And that just basically ensures that the property is going to be subject to tax. We're not going to take out the estate tax when one of the spouses dies. We're going to leave those funds available for it to be used to support the surviving spouse, right? For their use as long as it's left to them. Because we know that if it's left to them, they're either going to have to pay gift tax or estate tax on that, or at least expose it to it, even if it turns out not to be a taxable estate. Or they haven't yet made taxable gifts, but it would come into that realm. And there is a special category, though, called terminable interest property. If you leave it to the spouse, but you leave an interest that terminates, if a third party receives an interest in the same property and may possess it after the spouse's interest ends, that is not considered eligible for the marital distribution deduction, because it would avoid the spouse's estate. It is basically a bypass trust, is the most obvious standard terminable interest trust you see in estate planning, right? Is that. But in some cases, we would like to have a terminable interest because we would like the first spouse to die to be sure that the assets will go to his or her kids, not that the surviving spouse will redirect it to, whoever they basically start seeing romantically after you've died, or to their own kids only, or various other things they might do, or just disinherit your kids because they really didn't like your kids. So the Q-tip rule is an exception to the fact that terminable interest will not be allowed a marital deduction. If you meet the Q-tip rule under 2056B7, there are a lot of requirements to meet it, but if you meet that rule, there'll be a marital deduction allowed even if the spouse only has a life income interest. And so the property still passes to remainder beneficiaries designated by the first spouse to die. Now, the requirement for a Q-tip trust, there are basically three. The property must pass from the decedent to the trust. Doesn't do that. Doesn't count. The surviving spouse must have a qualifying income interest for life. General rule doesn't really matter here because she has it, but we'll talk about it generally. She's entitled to all, he or she's entitled to all income. She was payable annually or more frequently, and there is no power to appoint principal to others during the surviving spouse's life, and there wasn't. The executor must make an affirmative election to treat property as a Q-tip on the estate tax return. Number 3 is our problem. They didn't quite follow the instructions to get this done right. If a proper Q-tip election is made, we meet the other requirements, then the assets in the Q-tip trust are included in the surviving spouse's estate under 2044, or if they transfer before the spouse dies to the kids, then they would be subject to gift tax under Section 2519 if transferred during the life. Now, let's talk about the $2 million, the first bequest. Everybody agrees that was a terminal interest, right? For it to qualify for the marital deduction, it needs to meet the statutory exception, which means basically it needs to be a Q-tip in this case. The key problem was that the estate failed to provide evidence of a Q-tip election for the $2 million bequest on Schedule M of Form 10706. The return specifically listed this stuff as all other property, non-Q-tip, and did put on the Q-tip schedule. The court rejected the estate's argument for a substantial compliance approach, or that the IRS had waived the issue by not raising it during the audit. Doesn't matter. Should have agreed to the audit report, I guess is what we're saying here, assuming this was the big issue ultimately. Became a bigger issue than anything else. So the court reviews de novo. The court found, since no Q-tip election was made, that $2 million bequest, which was made to the trust, did not provide for what happened when, Maria died. That would basically be a terminable interest without a Q-tip election attached to it. As such, it won't get the marital deduction, and it's going to be counted as part of the decedent's estate. And presumably, with this being in court, Mr. Griffin, this will make his estate taxable, probably, to right around $2 million, right? Because presumably this was set up to capture assets beyond those he might want to transfer directly to his kids, or the ones he might want to put into a bypass trust to capture those others and Q-tip this. Okay. Now, the next one, though, what about that $300,000 bequest that did provide that even though it was going to a trust that said nothing goes, she can't assign it anywhere, can't go to her estate, can't pay her creditors. Remember, this bequest said it went to her estate. So the real question is, which provision governs here? Was this $300,000 bequest terminable interest under Kentucky law? Again, if it's terminable, it's includable. We've already decided no Q-tip election was made, so it would be there. If it's not terminable, it will qualify for the deduction because it would be part of Maria's estate just by its natural structure. Now, the crucial provision the court found was that the bequest stated any undistributed amount upon Maria's Creel death shall be paid to her estate. That's the key issue we're looking at, that particular phrase. Now, the estate said that provision was effective. It created a separate estate trust that would have its remainder distributed out to Maria's estate. So therefore, it's non-terminable. The IRS said, wait, this went to a pre-existing trust whose terms prohibited distributions to her estate. It says the IRS reads that as a void attempt to modify the trust terms. The remainder must pass under the terms of the trust as it was put into that trust to the descendants, his descendants making a terminable interest. The court's focus was, did he intend to make a separate trust for the $300,000? And most importantly, they're going to focus on the requirements to create a trust under Kentucky state law, because Kentucky was the law that governed this. Now, the court found that the decedent did intend to create a separate trust, and under Kentucky law, that will make it a separate trust. He used the term living expense reserve for this specific bequest, was not used for the other ones. This is a special, separate thing from the first one. It had a very distinct distribution upon death. It was going to go to her estate. That directly conflicted with the trust prohibition. Remember, that was written at the same time. So he was aware of that, which suggests that knowing that, he made the first bequest go into the trust with no restriction. So it would, in essence, at her death, not go to her estate, but go to the heirs that he had named. But the second one, he provided specifically would go to her estate. So that allows this to go through. The court said naming the same trustee was not conclusive. This goes back to the Old English common law arguments, what they are trying to argue, that really an estate is just a set of restrictions imposed on the new owner of the property who is the trustee. And the trustee has to operate, and handle the property in accordance with the trust requirements, right, for the benefit of the beneficiaries. But since he was handing it to this person in their name as title as trustee of that trust, well, then that trust rules, those specific rules of that should still govern it. They said, but the court said conflicting distribution terms indicated an intent for a legally distinct trust. This was a separate set of instructions. It nullified the to her estate clause in the trust, since using that term would ignore what's otherwise the decedent's clear intent in making this bequest. So that created a separate trust. Since this goes to her estate, it's not turnable interest, and it qualified for the marital deduction. It's not includable. Now, obviously, all of this could have been avoided if there'd been clear drafting. So that's probably the best thing at first. Review it, make sure it's clear, make sure there aren't things like this going on. Be a good idea when you have a trust document. The state law on trust formation is paramount. By the way, I'm suggesting as a CPA, I'm not suggesting you're an attorney and should be writing the documents, but I am suggesting you read the documents, right? And at least inquire about why this isn't a problem. That seems to be a valid exercise of your, because you have to apply the trust to the tax law, which means I do kind of know which one of these provisions is the one that does it. And under this trust, I seems like I could read it both ways. And I mean, hopefully, counsel will tell me I'm wrong, that it really can't be read both ways. But I want counsel to put that in writing, please. And to be honest, it'd just be simpler not to have vague terms like this. That'd be the easier approach, right? It would simplify matters if we had that. So that's kind of big. State law does matter. In a different state, there could be a different result. It could say anything goes in the trust. If you say it's going to the trust and you put it there intentionally, you're not really allowed to impose conditions. Would be kind of the argument that are directly, against those imposed by the trust. You should have read the trust. That'd be the theory. Not saying that any state will get you there. I think most states pay attention mainly to his intent. That'd be the key. It's important, too, to place strict adherence to federal law requirements, especially those in statutes. Like the Q-tip election, it's critical. When you're trying to get a benefit of something like the Q-tip election, don't rush through the job. Don't go with what you think. Check the law, check the instructions, check everything to make sure you're doing it exactly the way you've been told to do it, so there's no question about whether you made a valid election. That would be the key. Let's talk about reasonable cause for late filing. This is an issue we visited before. So we're going to look at the Boyle case again and an exception to the Boyle rule. Now, this particular case itself is a case of Vincenzo Sedanto versus United States of America. It's application of the reasonable cause exception under Section 6651A1 to timely file an estate return. So, exception to the late filing penalty. Now, this case highlights the importance of documenting advice. Because if the advice had been fully documented in writing and said what the executor heard, right, what she was now testifying she was told, we almost certainly wouldn't have this issue before the court. The problem we're going to find out is there were some things never written down that are going to cause us a problem. It's also very important to understand the detailed factual nature of the reasonable reliance defense to get out of a late filing penalty and what things you can rely upon a third party for and what things you can't. Okay. The decision came on a cross motions for summary judgment in this matter. Okay. Now, the decedent was Vincenzo Sedanto. He died April 12th of 2017. His property was in a trust. His executor was his sister, Rita Mayo. And the initial counsel for the estate was Mr. Sedanto's longtime attorney, Joseph Palumbo. He handled Mr. Sedanto's affairs for decades. The attorney prepared a written estate tax analysis and discussed it with Ms. Mayo, right? This analysis represented his final written statements we have available. Mr. Palumbo is, we do, basically he became very ill, left practice, so we have nothing more after this written document, right, in this case. Now, the estate missed the filing deadline and did not request an extension, while Mr. Palumbo was still retained. Months after the deadline passed, the estate learned that Mr. Palumbo had stopped practicing law due to illness, and they retained new counsel. The new counsel and the CPA found errors in Mr. Palumbo's analysis. and discovered an estate tax return was due, and estate tax was due. And so the return was filed 10 months late. Now, the IRS assessed approximately a $469,000 failure to file penalty and approximately $135,000 failure to pay penalty. Now, the estate requested abatement based on reasonable cause due to reliance on Attorney Palumbo's tax advice. The IRS denied abatement. IRS said, you cannot rely upon an agent for timely filing of a document. That's what you're trying to do. Now, on appeals, the appeals office fully abated the failure to pay penalty, but only very partially abated failure to file. Remember, at appeals, they can compromise an item, reflecting, kind of the risk of litigation. The reason they gave for partial abatement, reasonable cause was not fully met for the failure to file penalty. So the estate paid the remaining $444,000 failure to file penalty, no failure to pay penalty, and they paid the interest. Then turned around and sued for a refund, claiming reasonable cause for late filing based on reliance on Palumbo's advice that filing was unnecessary. Advice they claimed they were given by Palumbo. The estate claimed that his written analysis and verbal assurances to the sister indicate no tax liability was there and there was no need to file a federal estate tax return. Now, the legal background of reasonable cause for late filing. Failure to file is a mandatory penalty unless the failure is due to reasonable cause and not due to willful neglect. And the taxpayer bears a heavy burden of proof under basically the Internal Revenue Code, Section 6651A1, to show that they should qualify for relief. Now, the key Supreme Court ruling, when we're talking about an attorney or a CPA and a return not being timely filed, or an extension not being filed, is a case of United States versus Boyle, 469 U.S. 241 U.S. Supreme Court case from 1985. The Boyle case, which you definitely should know if you're in the business of preparing returns, is that, in essence, reliance on an agent, that includes CPAs, attorneys, EAs, reliance upon an agent for filing does not excuse late filing. The duty to file on a timely basis is a personal, non-delegable duty. The court's idea has been you don't need special advice to know that an envelope or something, electronic something or an envelope, needs to be submitted to the IRS by the due date, 9 months after date of death in this case. That doesn't take special expertise to determine a date 9 months from the date dad died, and to see that something gets mailed or submitted electronically by that date. That takes no special expertise, right, to know whether or not that happened. However, there is an exception for reasonable cause. They said that can exist when a taxpayer reasonably relied on the advice of an accountant or attorney, and that accountant or attorney said it was unnecessary to file a return, even if that advice turns out to be wrong. That's going to be their attempted defense here is that, Mr. Palumbo had told them no return was required, and they relied upon that, and it was wrong, but they reasonably relied upon that, and therefore that should get them out of the late filing penalty. And the reason for that is taxpayers are not required to challenge their experts on technical areas unless they have reason to believe that the advice they're getting is tainted. So that doesn't give you carte blanche to opinion shop. If it's clear you went to 12 attorneys, 12 CPAs, 12 EAs, right? And none of those basically all of those 36 told you, no, you can't do this. You can't rely upon the number 37. You pick which one of the three you want this person to be, who, let's say, is not the most competent and writes up and says, oh, yeah, you can do this, no problem. That's not reasonable reliance because you were clearly, in the area where you were doing opinion shopping. Also, you need to watch out for if it relates to a tax shelter, which this doesn't. You don't want counselor, an attorney who is attorney, CPA, EA, who is any way associated with promoter, because you're not going to get reasonable cause for that either. That's deemed to be something, assuming they don't hide the connection, that is a inherent conflict of interest. And you should recognize that and why you can't use that necessarily to rely upon it. They only get paid if you go forward. That's considered to be a problem. For reliance purposes, that gets rid of reasonable reliance, right? So the question became, did the estate reasonably rely on the attorney's substantive tax law advice that filing was unnecessary or not? Were they ever given that advice as a statement or not? Those are the key issues. Now, the estate asserted reliance upon Palumbo's written analysis and verbal assurances, and that filing was unnecessary. The sister claimed she relied on that due to her inexperience. She didn't know enough to know that maybe that wasn't proper. Now, the IRS argues that the written analysis was unclear, and Ms. Mayo admitted waiting for further advice. U.S. challenged the credibility of her claim of verbal assurances that represented that later advice. And the court agreed with the IRS that, the analysis presented two scenarios. One that said there was no need to file if certain real estate would not be part of the estate, didn't have to be counted. And the recommendations section noted no need to file taxable estate stayed below the threshold, right? Stated that. So the court agreed that analysis alone seemed to indicate that you could there's no advice given there. We need to get information about is the real estate have to be included? And if it is, does that drive the estate's value up above the level needed to file? Now, Ms. Mayo asserted that though she had, in addition to that written document, she had received verbal clarification from the attorney that filing was unnecessary, and so she relied upon that and didn't file. The key finding is a reasonable fact finder could accept her assertion about the verbal advice and her reliance. I mean, it is evidence of, of advice being received. It's not ironclad. There's no way this could be an error evidence, right? People do sometimes lie, or even not lying. She could simply have, basically not really understood the issue of what was exactly going to be telling you didn't need to file. So in any event, and then we got to look at, is it credible based on her background that what she got, let's say it was flawed in some way, that she should have recognized the flaws or not. And that's going to be based upon her background. So it's a credibility issue. And a credibility issue, the court says we can't deal with that at summary judgment. In essence, this needs to go to trial. A reasonable jury could find it reasonable that she relied on that verbal assurance given her inexperience and that she received it, right? We had that, her inexperience, her fiduciary role that was new to her, and her lack of tax sophistication, and the fact that, the long-term attorney, right, who was familiar with the estate had given her advice that she decided meant that she didn't need to file. Her reliance could be deemed reasonable under the Boyle standard despite the confusing written analysis. So because there are genuine disputes of material fact regarding whether the estate actually relied on substantive advice from Palumbo for any to file, and whether it was reasonable for the estate to rely on that advice, you got to go to trial. Whether the elements constitute reasonable cause are present given situation is a question of fact that is quoting from the Boyle decision. And these factual disputes are determined by a fact finder. In this case, it would be a jury that would do it because they asked for a jury trial. So the court denied the United States motion for summary judgment and the estate's cross motion for summary judgment and set the case for trial. Key takeaway: remember, reliance on substantive legal advice, not simply saying, file this, make sure we file this on time, and just giving the problem over to the to the advisor or the agent. That's not going to work. But you're looking for substantive advice that told them that they didn't have to file, things like that. Filing is unnecessary, could be reasonable cause. But but it's going to be a factual analysis, looking at the facts and was it reasonable? You know, did what you get was reasonable for you to read what you got as advice telling you didn't need to file? And secondly, if it was it reasonable for you to go ahead and assume that was correct given your own background, right? Those are going to be issues. So dispute over what advice was given, what it meant, whether reliance was reasonable, would likely preclude summary judgment, and it's going to require a trial, which is more expensive always. Documentation is key. As I said, we could have avoided this whole problem had everything been done in writing. If Palumbo really did give this advice, had he put it in writing, this whole thing wouldn't be going to court. Now it's got to go to court over this issue. So it's important to make sure the advice regarding filing requirements is clear, well documented, and complete. Don't leave things hanging, and make sure the client, as long as you're not sure there's no requirement, you really need to emphasize to the client that something needs to happen by this date. We either need to be sure we're not required to file, or we need to file at least an extension request for the 706 by that date. And the taxpayer should understand that claiming reliance will face scrutiny. It'll require factual proof, and don't just try to paper over it by finding some expert, quote unquote expert, that'll say what you want to hear, because that will also be considered evidence of non-good faith. The problem. Let's talk about the No Tax on Tips Act, passed unanimously by the United States Senate this past week. Right? It was passed on May the 20th. Voted unanimous consent was granted to bring it immediately to the floor, and it passed unanimously. The stated purpose is to eliminate the application of income tax on qualified tips to an individual election. It also includes provisions for employers' Social Security tax credit on tips to handle this area. There are similar but not identical provisions in the House One Big Beautiful Bill. A bit more about that bill in general here shortly. The key provision, it would add a new section 224, same section be added by the House bill. Allow deduction for amount equal to qualified tips received during the year. Now, those tips must be included. This is where you're going to see a problem because the law says cash tips. It says cash tips both here and in the House bill. Cash tips will be those that must be included on statements furnished to the employer under 6053A. Been a lot of bad definitions of cash tips making their way on social media, and your clients may probably have run into those by now. Cash tips in this context is not looking at cash versus credit card. It's looking at cash versus tangible property generally. So what it is, cash tips on the IRS page describing to employees what they need to report to their employer, includes the amounts that are received and paid by customers with credit cards, therefore, but are then paid to these, to basically to the employee in cash by the employer from what comes through, because obviously the money goes to the credit card person, right? And so that's kind of the big thing. When the money goes to the credit card person, well, they got to get that money over to the employee, normally via their paycheck. That is still a cash tip. That still qualifies for subtraction. If your clients believe it doesn't, you probably need to correct them on that. It does. There are other restrictions, but it works there. First restriction is you can't deduct more than $25,000 per year. So yes, the tips will be in their W-2. They are subject to FICA, but they will be able to subtract up to $25,000, and it'll be based on that number on the W-2. That's where the number is going to come from and be cross-checked. At least in the Senate bill. The House bill allows self-employed to get it. They're obviously going to be a little bit tougher to cross-check the tips. Now, one other thing we got a deduction for qualified tips. Whenever you see the word qualified tip, you see qualified anything, it means there's a definition hiding somewhere. This is no different. The law provides a qualified tip means any cash tip. That's where the cash tip rule comes in. Remember, cash does include those paid by credit cards that are paid out to the employee on their paycheck. Any cash tip received by an individual in occupation traditionally and customarily received tips on or before December 31st, 2023. So that's important also. Now, if you try to get ahead of this, you decide, hey, in 24, you knew that this is being talked about by both candidates. Well, I'm just going to start taking tips in my accounting practice. Yeah, it's not going to give you an exclusion. Yeah, it doesn't work. The Treasury will publish a list of these traditionally tipping occupations no later than 90 days after enactment. Now, certain employees cannot claim this. So now we get to the other exclusion. In addition, not being able to claim if it's over 20, not being able to claim tips over 25,000, you also can't claim them if you are a highly compensated employee as defined by the amount in effect under Section 414 Q1B little I. That is in the qualified plan section. That's a highly compensated employee section, where if for a non 5% owner to be an HCE, you must have basically in the prior year have had compensation in excess of $160,000 in 25. It is inflation adjusted each year. So that means since the effective date would be for 25 returns, if your employee who got paid tips made more than $160,000 in 24, they can't deduct any of the tips they receive in 25. That'll be the block. Now, obviously, deduction for qualified tips is treated favorably. You get it whether you itemize or not. If you're a non-itemizer, it would be added to the list of deductions in Section 63B, or an above-the-line deduction. If you itemize, it's not treated as miscellaneous itemized deduction subject to 2% floor. It would not be taken into account or overall limitation of itemized deductions under Section 68C. So you're going to get that one too. You'll get it either way. The Secretary of Treasury is required to modify withholding tables and procedures to account for this new deduction. So in theory, employees will be able to reduce their withholding. Probably, I would suggest ultimately that they will have you certify that you're not, you do not expect to receive tips in excess of $25,000, and you didn't earn more than $160,000 the prior year, or at least, or certify that your only income the prior year for earned income came from this employer, so they can double check you. Did you get over 160? That'd be the background. Now, the other part of this, Section 3 of the Act, Section 2 puts in the subtraction. Section 3 is a credit for Social Security taxes paid on employee tips under Section 45B. It proposes to extend this credit to beauty service establishments. The credit applies to tips received in connection with providing food or beverages, if customary, and providing beauty services to a customer or client if tipping for such service is customary. As of December 31st, 2023. Beauty services are defined to include barbering and hair care, nail care, aesthetics, and body and spa treatments. Right. The credit calculation under 45B1B, the reference to minimum wage as in effect January 1st, 2007, will only apply to food and beverage establishments, and the effective date, both the individual deduction and the employer credit extension, would apply to taxable years beginning after December 31st, 2024. Okay, there's a big transfer pricing case that came up with Facebook and subsidiaries versus commissioner. Now, this is not my area of expertise. I don't work with companies the size of Facebook, so I will admit that right off. But if you do have this on your plate, you really want to get the Facebook case and look through it, because this is a rather big one. One of the first ones coming out, there was an attempt to challenge regulations issued in 2009 for this particular type of issue. The key issue is the application of Section 482 and the temporary cost-sharing regulations at 1.482-7T to a cost-sharing arrangement involving the transfer of high-value intangible property, online platform technology users, advertisers, data, and marketing intangibles. First time those 2009 cost-sharing regulations were applied by the tax court. Now, the entity in questions here is going to be Facebook Inc., Facebook US, would be the reference in here, and its Irish subsidiaries, FIH and FIL, which collectively will be called Facebook Ireland. They entered into a cost-sharing arrangement, a CSA, effective December 15, 2010. They involved a platform contribution transaction. They were going to compensate each other for existing platform contributions. Facebook US granted Facebook Ireland rights to existing online platform territory users, or online platform technology, get that right. The users they had, advertisers, data, and marketing intangibles in the rest of the world territory, and Facebook Ireland granted Facebook US rights in the US and Canada. Now, Facebook Ireland, a cost sharing transaction, makes annual payment to Facebook US to share ongoing intangible development costs. These payments are based on Facebook Ireland's share of reasonably anticipated benefits from exploiting these cost shared intangibles. Facebook US valued the upfront PCT contribution, the platform contribution technology contribution, at a net present value of $6.3 billion. And Facebook Ireland made cost sharing transaction payments and contingent annual payments based on this as well. As we'll discover, we're going to have a little bit of a fight over that $6.3 billion. Now, the IRS determined a deficiency for 2010 by reallocating under 482. 482 is a section that allows you to, with related companies, reallocate income items, income or deductions, if you believe that the current structure of what's been reported, is essentially abusive or doesn't clearly reflect income. Now, what the IRS did, they used the income method to value the basically platform contribution, technology contributions. In essence, the opined the net present value of assets contributed by Facebook US was not $19.945 billion, just under $20 billion, not 6.3. So yeah, we're not in the same ballpark as 6.3 billion. This valuation of the PCT contribution would affect Facebook Ireland's required payment under the PCT, and they also increased Facebook Ireland's basically reasonably anticipated benefits share used to determine its cost sharing treatment payment for 2010. And it calculated that RAB share as 53.5%, up from 44% that was reported by Facebook. Now, Facebook timely challenged this determination. They challenged the method. They contended the income method was improper for both Facebook US and Facebook Ireland, who made non-platform contributions, saying that would favor using the RPSM method. They also said, okay, if we have to use the income method, the IRS's inputs are all fouled up. Right? Their rest of the world revenue projections, their appropriate discount rate for projections, Facebook Ireland's best realistic alternative to cost sharing, and Facebook argued correcting these inputs would support its $6.3 billion valuation. Simultaneously, they challenged the validity of the 2009 cost-sharing regulations, arguing they improperly limited expected return on the IDC and cannot produce an arm's length result. They challenged also the reasonable anticipated benefits calculations, the shares. They challenged those adjustments to RAB shares for the CST payments, and they also had a challenge to periodic adjustments that were made. They argued the IRS precluded from making the PCT allocation because Facebook Ireland's actual returns fell within a permitted range under this periodic adjustment rules of Temp Reg 1.482-7 I6. So what's a basic legal framework of 482? It authorizes, as I mentioned before, the Secretary to allocate income or deductions between controlled businesses to prevent tax evasion or to clearly reflect income. Income from intangible property, its transfers must be commensurate with the income attributable to the intangible. The standard was established in 1986. It was going to shift the focus away from solely relying on comparable transactions. The transfer pricing regulations that applied the method for 482 were found at 1.42-7T, or Section 7 is noted here on your slide. They address the cost-sharing regulations. 2009 regulations were applied by the IRS in this case. And the cost-sharing arrangement's objective, they determine the arm's length amounts for the transactions contributing to developing intangibles under a CSA. Now, the methods to value the platform contribution technology includes using the CUTCUSP method, income method, acquisition price, market capitalization, RPSM, unspecified methods also would be there. But it must follow Regulation 1.482-1. Just the best method, comparability, arm's length range. Now, the best method rule requires selecting the most reliable measure of an arm's length result based on facts, primarily comparability and data quality. CST is governed by the RAB share methods, right? People who share IDCs based on RMB shares. And the commissioner's discretion is very broad under 482. Allocations are set aside only if they are arbitrary, capricious, or unreasonable, meaning against the arm's length range. Court uses best judgment if the IRS allocation is unreasonable or improper, or the taxpayer doesn't prove arm's length alternative. Post-transaction evidence related to what was reasonably anticipated. So, what did the court say here? Well, let's talk about the application. On the PCT method selection, method for paying somebody, right? They found only Facebook US made a routine platform contribution. Ireland did not make one back to the US subsidiary. Therefore, the income method applied under the regs. That there was a no choice under the regulations 1.487-7T. No choice. The income method inputs, there the court agreed with Facebook that the IRS had totally messed up the inputs, right? They're unreasonable by using unreliable inputs. They thus abuse their discretion as to the extent of the allocation. Reliability of a projection, the court found, depends upon financial projections. They rejected the use of the LLP-based case, including other review as unreliable, adopted the LRP projections, right? Excluding other revenue. They excluded acquisition expenditures, right? The discount rate. They rejected the IRS experts' purely judgmental additions. They found weaknesses in the experts' methods. They adopted a 17.7% WACC from Facebook's original EY documentation as the most reliable. And for the realistic alternative that Facebook Ireland could have pursued, they rejected the IRS's cost plus 8% based on controlled transaction. They found issues with Facebook's reseller approach. They adopted the IRS experts' cost plus 13.9% markup from a CPM analysis of advertising agencies as more reasonable for the licensing alternative. Right? They approved that income method on an aggregated basis for technology, users, data, and marketing intangibles as they were interrelated. And the court held the 2009 regulations were not invalid. They reasonably implement 482 as written. Section 482 does not mandate external comparables where none exist. Focusing on internal allocation was appropriate for the service to do in the regs. The commensurate with income standard moved away from sole reliance on comparables. The income method does compensate the payer, and entrepreneurial profit is returned via the licensing alternative, and rejected arguments based on academic literature, the major questions or non-delegation doctrine, and the narrow definition of intangible property. Now, obviously, the major questions non-delegation doctrine is going to be more interesting. That's one the Supreme Court has used. So sounds like Facebook is setting up for some appeals to come in this case. The court held periodic adjustment rules under Temp Reg 1.482-7T-I6 do not operate as a safe harbor, precluding a PCT allocation under paragraph 2I3. The adjustments are not independent. And for the cost sharing transaction payment for the reasonably anticipated benefit shares, the court held the IRS method of calculating RAB shares using NPV of projected profits into perpetuity for the next year, for each year, and all subsequent years consistent with the regulations, which is the entire period and the most reliable. IRS did not abuse discretion in adjusting RAB shares using this method, though the inputs needed somewhat significant correction. Outcome, the court ordered parties to recompute everything using what they'd come up with, right? The court estimated a PCT payment value of $7.786 billion using these inputs, higher than Facebook's, but way lower than the IRS's. Remember, Facebook was at $6.3 billion. IRS was up nearly at $20 billion. And the court finally decided the real number was under $7.8 billion. So quite a bit closer to Facebook's number. The court will scrutinize the inputs to the method, reject unreliable ones, and substitute its own finding based on the record when it does this. The detailed analysis of financial projections, discount rate methodologies, and realistic alternatives is critical to this to figure out what the valuation should be. You want to document your basis for key inputs like discount rates. Right? Documentation is always crucial. What was the thinking process and how do we get there? And the case underscores the factual nature of transfer pricing disputes and the need for robust supports for any valuations. Final case, we're going to take a look at New York. And if Zelinsky sounds familiar, it's because, yes, 2003, you probably heard about the Zelinsky case. Well, Mr. Zelinsky is decided to come back now and try again. And this is going to be a case challenging New York's convenience of the employer rule for non-residents who are working for a New York-based employer. Now, this case was Edward and Doris Zelinsky, New York Tax Appeals Tribunal, cases 830517 and 830681, came down on May the 9th. The key issue was, how to apply the New York State's convenience of the employer rule to a non-resident employee working remotely for a New York employer, including during the COVID-19 pandemic, when, for the most part, you weren't allowed to go to your office in New York unless you were an essential employee. And, in this case, Mr. Zelinsky was not deemed essential. The background, the petitioners, Edward and Doris Zelinsky, are Connecticut residents. Right? Mr. Zelinsky is a professor at Yeshiva University, the Cardozo Law School inside that, in Manhattan, New York. Now, he had prior litigation. I told you, been down this before. 2003 case you can find, that Zelinsky versus Tax Appeal Tribunal of New York, basically, which was decided by New York Court of Appeals in 2003, was denied by the U.S. Supreme Court. And that upheld the rule's application to Zelinsky. Now, Zelinsky said things have changed. And you got two different cases where things have changed. One, a change in court precedent since the Zelinsky case was decided in 2003. Number two, the COVID-19 thing, where employers told employees to work from home, and how that would impact the convenience of the employer rule. Okay. Well, in 2019, a work situation was stipulated to be basically the same as in 94-95. He commuted some days, worked from Connecticut home, performing scholarship admin on others. He filed an amended return allocating income to Connecticut for days worked at home. The division was denied based on the convenience rule. This was a straight, flat-out convenience of the employer case. Nothing fancy here. This is the one that he's betting on change in precedent on. Number two is the one that he's going to bet on COVID. In 2020, he worked in New York until March 15th. Then from March 16th to December 31st, compliance with the governor's orders, he worked from, basically at home, right? So he would be there from that point, working exclusively at home, both due to basically government Cuomo's executive order and Cardozo's closing policy in reaction to that order. So there was no physical office or classroom available for him in New York that he'd be allowed to use, by his employer. Again, like with the first one, he filed an amended return allocating most income to Connecticut. And this case, the division partially denied based on the convenience of the employer rule, stating that, the COVID-19 thing doesn't really change anything in this case. Those orders don't change anything. Okay. Now, General, he argued that basically the finance division of the state of New York improperly allocated salary to New York for days when he worked at home in Connecticut. For both years under challenge, he presents the constitutional arguments. These are arguments that he basically presented in his last case, but he's going to cite new precedent. He said it violates due process, convenient rules violates due process, dormant commerce clause, resulting in unconstitutional extraterritorial taxation. The 2003 Zelinsky ruling has been eroded, he claims, by later Supreme Court cases in Midwest Vaco, I like that, and Wynn are the two cases they cite. Now, they also say, the estate says in 2020, now they're going to attack necessity, even though it might have been, right? Otherwise, and the question is, was it required to be done from home by the employer? Days work from home after March 16, 2020 were out of necessity for the employer due to the executive order and the unavailability of office and classroom space. Income for this period should be sourced to Connecticut, he argued, and the convenience rule was inapplicable. There was no New York office to go to. It wasn't like he could just, go to New York and work. He couldn't. He had no office space. He had nowhere to go. He would be camping out on the street, apparently, unless he wanted to rent his own space. So he said, look, Connecticut, clearly I had to work from Connecticut, my home. That was for the convenience of the employer to have me in Connecticut because they had no place to put me in New York. He also argued that the administrative law judge improperly omitted facts and points of scholarship, which of course function, not ancillary. 2003 case had held that such things were ancillary. He's saying, nope, that's wrong. You need to do that, and then that changes the most important things being done because the scholarship didn't require being in front of his students to basically be a lecture, give the lecture. Now, what is the New York sourcing and the convenience of the employer rule that how does it impact that? General rule, New York taxes non-residents on income derived from New York sources. That includes business, trade, or occupation in New York. If services are performed both within and without New York, the income is allocated based on days service performed within New York and days service performed without New York. So, for instance, let's say that I am, employed by my employer here in Phoenix, and maybe, I do repairs on specialized items. And a client in New York has a specialized piece of equipment. They need it fixed. Let's say that this was a custom thing. So I'm going to have to work down here with those that fashion such things to actually get the custom part remade and to get it properly put together and verify it meets tolerances. So I'll be doing that work in Phoenix at our manufacturing facility. And then I would fly out to New York State and actually do the performance of the actual, putting it into there. And yeah, maybe I am employed by a company in New York, or maybe no, I'm not in this case, not employed by that. Obviously I have work in New York where I'm physically there and I'm putting this thing in. Work that had to be done in New York because there was no other option. And then I have work that was done in Arizona. And while it's arguably for the New York customer, the reality is it's really for my employer, who is the Phoenix manufacturer, that's going to send me to New York to put this in. So that would allow me to split those days. However, if the convenience of the employer rule comes in, things are changed. You're not allowed an allocation for days worked outside New York unless those services are performed out of state, out of necessity, as distinguished from convenience for the employer. If it's for the employer's convenience, then it's treated as worked in New York. So, and this works for things like this. And let's say, especially during COVID, people got offers like this. Let's say, we all know it's been tough finding people to do tax work, right? Tax preparers. So we offer to a tax preparer that we find, just perfectly set up, perfectly fine. It's going to be the person we want. It would be great, right? It would be exactly what we want. But the person says, well, I'm only going to work for you on the condition that you allow me to continue to perform services, to do my work in whatever other state you want to pick. Let's say Arkansas. Well, that's not considered convenience to the employer. If it's the only way I could get this person was to hire them. The only way I told them I'd only work with them here. The convenience to the employer is having me working for them because otherwise I couldn't. They said, no, that's not, that's your personal convenience. The employer has no reason to have a tax preparer in Arkansas, as opposed to having one in Mississippi or having one in New Mexico or in Hawaii or in Washington State. The employer has no reason that you need to be there. And since they have an office in New York, It's for the convenience, your convenience, that this service for a New York entity that's being received in New York is not taking place in New York. It's your convenience because that's what you're doing. You've negotiated for that. So that is the convenience of the employer rule. So if somebody's hired by a New York employer and you're doing that work outside New York, like here in Phoenix, basically, as long as you have at least 1 day present in the state, that is part of the rule now. As long as I spent at least 1 day, go to the office in New York for 1 day, at least during the year, all of my wages will be considered New York wages, except to the extent that there is something they assign me to do that absolutely requires you to be in Phoenix to do it, which probably will be nothing, right? That'll be the key. So that's how New York casts a wide net, and it's very difficult to escape the convenience of the employer rule. Our question today is that rule legal? And even if it's legal, did Mr. Zelinsky, in the view of, the court, manage to meet the requirements so he could treat that as non-New York income or income earned in Connecticut? Now, he argued constitutional limits. He said the Constitution requires a minimum connection to the state and rational relationship between the tax and values connected to the state. That's what due process requires. That one's pretty easy to meet. The connection to the state can be very minimal. I mean, he's signed up to lecture for a university located in New York, in Manhattan. It's like, okay, there is a connection, and is there a rational relationship between the tax and values connected to the state? Yeah, he gets access to the New York market by being connected to that university that is in New York and that is protected by New York laws. So there's value to him of having this, of having this New York employer, right? So there's a rational relationship between the tax and the values. This person's there. He needs, he's getting a New York employer. That's his relationship back. So they're going to say, well, that helps us. And then the other part is the Dormant Commerce Clause. It requires the state tax and interstate commerce to be fairly apportioned. Fair apportionment requires 2 tests. It must be internally consistent. This is probably the big one people misunderstand. If every state had exactly the same rules as New York, including granted credit for taxes paid to other states under the same conditions as New York does, would we end up with any time we would pay taxes to both New York and another state without getting a credit to help offset them? It's not saying that if you do have that situation where you're, let's say you're paying tax to Connecticut on these wages and Connecticut's not giving you a credit for the New York wages, but New York's taxing it as well. You might say, well, that's double taxation. Yeah, it is. But it's perfectly legal, because if New York used Connecticut's rules, there'd be no double tax. And if Connecticut used New York's rules, there'd be no double tax. Connecticut used New York rules, they wouldn't, they basically would give a credit for the New York wages paid. And if New York followed Connecticut's rules, they wouldn't consider it New York wages. So in either case, they're there. And the Supreme Court said the problem with requiring consistency to, mean nobody ever pays a double tax in the real world is you'd have to tell me which state has the unconstitutional provision, New York or Connecticut, because I need to invalidate one and tell them they have to use the other. And do I then mean I've just ruled that for all other states, that same thing must be true? So either everybody must do it like Connecticut or everybody must do it like New York, or do I go study all 50 states, or at least those with income tax, and decide the best option, and then just all the other states got to use that? That's not how it works. You also have external consistency. The taxes only reaches income reflecting an in-state activity. And basically, in this case, it's going to be the tax only affects wages for the New York employer for work done, for the convenience of the employee outside of the state of New York. That didn't require, didn't have an employer requirement that forced you to work in that other state. Okay. New York court, including 2003 Zelinsky cases, have upheld the convenience rules as constitutional. 2003, Zelinsky found sufficient connection with physical presence and availing themselves of the New York market for employment. Now, the analysis of the tribunal. First, they said the administrative law judge had properly reflected the record. 2003 ruling characterized non-teaching duty as ancillary. Nothing else has changed. They did make a mistake there. The court also held the 2019 situation was identical to 2003. They applied stare decisis and said the 2003 Zelinsky case is controlling, right? They're not going to follow any of the other stuff he says has changed it since then. None of that has changed 2003's decision. So based on that, they're not overturning it. And 2020, the necessity argument, right? They're rejecting his rules that there was no longer an employer necessity issue involved. It was actually the necessity was he had to work in Connecticut because his employer, assuming they wanted his services, need him to work outside of New York because they could not provide him with an office. He couldn't come to their New York office. Now, the problem was the unavailability of that classroom due to the executive order did not mean out-of-state work was for the employer's necessity in the location he did it in. Cardozo, allowing work from home regardless of location, is not necessarily for that specific location. Well, yeah, you couldn't work in their offices in Manhattan. That didn't mean you could only work in Connecticut. I understand the practical limitation here, right? You're going to work in Connecticut because why would you spend the money that you had to spend to get space elsewhere? I mean, why would you ever do it? You wouldn't. But that's not the issue. They said if you allowed people in this case, you just said that was considered to be working at a specific location, that would be a concession of essentially unwitting interstate actors. They would say other states could use that as a concession that they were doing business in the state. Hint, other states probably going to try to use that anyway, but that's a different issue. They distinguish the matters of fast as limited. The question is if the employer required out-of-state work for its necessity, not merely permitted it. The petitioner did not show Cardozo required him to work from his Connecticut home. So the constitutional arguments, they limited that to as-applied challenges, a concept we've discussed here before. As applied means we're not going to consider a theoretical case where it would violate the Constitution of the U.S. under the Due Process Normal Commerce Clause. We're going to consider whether it does violate it in your case. That what's more important is, are you suffering constitutional harm? Not is some theoretical person might suffer constitutional harm. And so because of that, you who are suffering no constitutional harm is not going to get relief. It's not going to happen. That person needs to come down here and do their own arguing to get relief. So they reaffirmed there was sufficient connection via physical presence and availing of the New York economic market, in his case, employment. His New York tax was limited to New York source income, not extraterritorial values outside the state. And the tax was not disproportionate based on the work he did in New York versus the work required to be done outside New York. Right? Remember, outside New York. He could have gone and got an apartment in some rural part of New York State and done his work in New York. Why he would, I don't know, but he could have. So nothing said he couldn't do the work in New York. That's basically the problem we've got here. On the Dormant Commerce Clause, they looked at both internal and external consistency. They found New York rules internally consistent. Again, everybody taxes the way New York does. There's no double tax. Any potential double taxation arises from the other states' schemes, not New York's. Right? That's how you look at the states. Connecticut's not giving a credit is Zelinsky's problem here and why he's getting double taxed. And they're saying, well, we don't have to follow Connecticut's rules just like they have to follow ours. But we do have, we just have to have it internally consistent. If either one of us did it that way, either one of us was using the other rules, then there'd be no double taxation. And they also said there was external consistency. New York tax on income derived from New York sources only is sorry from New York employer. Allocation rules limit the tax in-state activity, employment within and without New York, that's not required to be performed elsewhere. That reflected the in-state component. They rejected arguments that Medwest Vaco and Wynn had eroded the 2003 Zelinsky's application. They also noted the Supreme Court had denied a lawsuit by New Hampshire challenging Massachusetts' rule that was during the pandemic. Now, that's a little, what can I say? Not really going the whole distance on that one, because that one was dismissed as moot. Never actually decided if Massachusetts could have done it. They said it's a done deal. Everything's over now. There's no longer a matter before the court. We're dismissing it as moot. Okay. Now, the conclusion, they denied the petitioner's exception and affirmed the administrative law judge's determination. The refund denials, the petitioners challenging denials of their refunds were denied. They don't get the money. The finance division's actions were sustained. Now, the key takeaway is understand the convenience of the employer rule remains applicable, at least per the New York courts. Non-residents working remotely for New York employers, even during COVID. The fact you could not have worked in New York is not an argument against it, at least per the New York courts. Working from home due to employee convenience, including choosing to live out of state while employed in New York, means those days are still New York work days. Some people, when they couldn't go to work anymore at the office in, say, down Manhattan, and got forced in remote work and discovered they liked it, may have relocated somewhere different. I know I have a friend who is a CPA that was working in Seattle when COVID does. She's been living in Seattle for a long time. Family situation is changing. They now have a very young child. But she'd been a long-time employee of the Seattle accounting firm. And she relocated to Indiana to work remotely. Right? If you weren't going in the office in the Seattle area, you're going to be doing it via the internet. Why does it matter if you're in Seattle, a Seattle suburb? The state of Washington, Indiana's works as well as anything. And it was much cheaper getting a much bigger home in Indiana. So that was kind of the second part of the deal. So she discovered that money went along a lot further for a house in Indiana that they were going to need to raise the kid in. So bingo, off and running. But that was due to employee convenience. She would even say, that's my convenience. It's not my employer's. Right? Again, I could have stayed in Seattle and kept working in Seattle. Wouldn't have been a problem. The key takeaway, working remotely due to the COVID-19 pandemic, state executive orders or office availability did not meet a high bar of necessity of the employer in this case. The employer allowing remote work where the employee chooses or must be located is not the same as the employer requiring the work to be performed in that specific state location. Or somebody points out, I realized that Washington doesn't have an income tax. Wasn't really relevant to her. And Indiana was not about to say that you don't get to pay tax to us because you're working for a company in Washington. Yeah, she kind of walked into an income tax. But look, everything else was way less expensive. So yeah, it was kind of like overall, as she would say, net gain. Right, in that case, and it's not really the tax side of it that was a net gain, it was everything else. Yeah, and of course she would say that because she will constantly remind me she's not a tax person. Doesn't do tax stuff. So we have that issue. The tribunal continued to uphold the convenience rules against the due process and dormant commerce clause challenges. Okay, so they say that nothing's changed there despite Supreme Court rulings, and the case reinforces the rule. It reinforces rules' impact even after pandemics. Now, I think it's very clear that Edward Zelinsky wants another shot at the U.S. Supreme Court. I don't believe he even thought he had a chance of winning this case at the state of New York level. But he needs to get up to the top tribunal in New York, to basically the Court of Appeals again, get them to knock it down again, and then he can ask the Supreme Court to hear the case again. We'll see if they take it. In the Massachusetts case, they sidestepped this convenience of the employer theory entirely. Is that an indication that they're going to rule for New York again, or they're going to at least not pick up the case? Or can he now get them to pick it up? It's interesting to see what happened. It is a different court than it was in 2003, so that could make a significant difference. There are a lot of different people on the court that weren't there in 2003, and a lot of people missing who were there in 2003. So that's part of it. This has been the Current Federal Tax Developments for May 26, 2025. Current Federal Tax Developments are brought to you by Capital Financial Education. and, are basically not by Kaplan. Actually, I forgot. They're not presenting it anymore. Rather, it's just your state society of CPAs. So keep that in mind. Kaplan is no longer doing full day live or live sessions basically for Kaplan. They're kind of more into a self-study mode. So they'll offer it, so it's there, but not really the mode I had before. So I'm generally a live webinar person. So I'm doing live. And that's kind of what I like to do. So we're doing that background. I also greatly prefer doing live, where I'm actually on the other side of the mic and the camera when it goes on. I understand replays are somewhat of an economic necessity for many cases, or just a convenience necessity because sometimes you need to do things and it's important and people need to have multiple times to pick it up. And generally in that case, you always know the first run is the live one, right? Second run will be the taped version. But how that goes. So anyway, that's there. Also, want to remind you that you can email me, edzollars at currentfederaltaxdevelopments.com. edzollars at currentfederaltaxdevelopments.com. Get that right. I also follow the Connect sites for the Arizona, Idaho, Minnesota, New Jersey, Washington, basically, and Illinois. Get all the states in there. Got to remember them all. Societies. So if you have questions, you can post to those locations. I might see your question. If I think I can give an answer, I may reply there. So take a look there as well. Otherwise, I'll see you guys all next week after our short 4-day week this week with more current federal tax developments.